Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Very recently, the Honorable High Court of Andhra Pradesh, Justice Gannamaneni Ramakrishna Prasad, in the case of GURRAM Bhagyaraju versus State of AP, in writ petition 4002 by 2023, on 15/6/2023, delivered a brief, brilliant, balanced and bold judgment, awarding exemplary caste to the HOD, and also he has dealt with the right to education and the process of the admission and the lacunae on the part of the so-called HOD and others. And he has very beautifully, that is commendably, cogently and convincingly issued the so-called orders in the judgment. As students, you have to understand the legal maxims. He has mentioned res ipsa loquitor. Thing speaks itself. Here he mentioned, after knowing the brief fact, then we'll come to that point. And he has awarded the exemplary cause. Actually, he passed caustic remarks stating that a man of ordinary prudence will understand the prospectus, but the man with a brilliant, bright academic career, he should not have done like that. Right? With this intro, let us go to the facts of the case. Already I told you the name of the case is GURRAM Bhagyaraju. This GURRAM Bhagyaraju, he took admission in the second counseling in the convener quota in the AP PG set 2022-23. That means he is studying MA Rural Development, from Acharya Nagarjuna University, having passed the PG set examination for the academic year 22-23. He paid the fee. Here the subjects are the qualifications and other things. His documents have been verified, and ultimately he was given admission on 15/12/2022. He has paid the prescribed fee and he started attending the classes. So he started attending the classes for MA Rural Development. Suddenly, after 20 days or so, after 25 days, on 10/1/2023, the University College of Law and Arts, College of Arts and Commerce, he received a letter regarding this particular student from the HOD, Mr. Divya Jyoti Murthy or some Divya Tejo Murthy or somebody. He was the HOD, stating that by oversight or by mistake, his admission was given. According to AP PG set, the persons who have pursued the master's degree in professional courses, they are not eligible for admission in this particular area. And the prospectus, they have clearly shown what are the professional courses. Friends, already I told you, in the very famous case of VP Shanta, Indian Medical Association versus VP Shanta 1996. So what is a profession? What is an avocation? Who are professionals? There itself we discussed that the BE, BTech, MBBS, BUMS, here also in the prospectus they have written. These are the professional courses. But this man has completed his MBA within brackets IB. So whether it is professional course or not, as per the PG set, it's not a professional course. But under the impression that it is a professional course, they have cancelled his admission. Now he has no other go except to approach the Honorable High Court of Andhra Pradesh. Mr. Karmanchi Indanil Prasad, on behalf of the writ petitioner, he started saying that the judgment, the issuing of orders of the HOD or the principal, they are perverse, illegal per se, all these things. Of course, the Honorable High Court, the Justice, single judge, He has gone through the contents of the petition. As usual, asked a counter affidavit. It was filed by Professor B. Karuna, who is the in charge registrar of Acharya Nagarjuna University. So, after summing up all these things, the court, on perusal of the prospectus, a man of ordinary prudence, please remember the words, a man of ordinary prudence and minimum education could have read and understood the eligibility conditions. That means a person who is a professional, having professional degree, he cannot undertake. But here, MBA, it is not a professional course as per the prospectus. And as regards the qualifications of the so-called HOD, that is the Divya Tejamurti, a man of high scholarship, a high scholar. His qualifications are MA, BEd, MPhil and PhD also. Then did he not go through the prospectus? And he is one of the people who has issued the guidelines. That's the main problem. Right. Now, coming to the counter affidavit, I tell you the topic of res ipsa loquitur. The counter affidavit under section 139 CPC was filed by Professor B. Karuna. And the material in the affidavit is quite contrary to the prospectus. So that's why the judge stated it is res ipsa loquitur. Thing speaks itself. Finish. When the so-called registrar was present before the court on 10/5/2023 or so, she admitted that believing the HOD, she has signed the affidavit. It's a bona fide mistake. And now they wanted to correct the same. Of course, after going back on the same day itself, instructions or directions were issued cancelling the cancellation order. Cancelling the cancellation order. Of course, the matter was, it has come to an end on 12/5/2023 when the standing council stated that already he has been giving once again the admission. But here what we have to learn is the learned people, university, Vishwavidyalaya, and the all learned people, the professors, this HOD is having so much of qualification. Is he not able to understand the difference between a professional course and an ordinary course, or the prerequisites for the so-called admission? What is that they are doing? Having given admission, how can they cancel the same without verification? Okay, whatever it is, by mistake, they have clearly, by oversight, they have given the admission. Okay. Then, before cancellation, they must be doubly careful, which they did not at all take care. Right, the matter went to the court level. When the matter goes to the court level, while filing the counter affidavit, I already told you that the affidavit should show the facts which are known to you or the facts which are exclusively within your personal knowledge. Without that, simply signing, where does it lead? She is also a professor. So, therefore, the High Court has lambasted on all of them. So, please remember, the High Court placed reliance on the case of Municipal Committee Hoshiarpur versus Punjab State Electricity Board and others, 2010. And now, lastly, the High Court Justice also said that definitely the boy, he is a student. He is not a litigant, regular litigant. So, therefore, the cost for the litigation should be borne by the so-called HOD. So, therefore, he has awarded 25,000 or 15,000, 25,000 to the university, of course, to the HOD, but the university should not be saddled with the burden of paying that amount. So, the registrar will collect the amount from the salary of the HOD and pay it to the student. Very beautiful, bold, and I can say it is a path-breaking judgment given by Justice Gannamaneni Ramakrishna Prasad, declaring the educational qualifications are not enough to understand like a man of ordinary prudence. At least is how the HOD should have applied his mind as a man of ordinary prudence. So please remember these directions, please remember these given by the Honorable Justice should be followed by other universities also. Right, with this I am concluding. Thank you very much.